Why have we done a webinar on dealing with employees with less than 2 years service? Well, it's one of the biggest mistakes that many employers make. The rules framed by the government state that unfair dismissal only comes in for employees who've been with you for more than 2 years. But to compensate for that, there are plenty of other reasons why a dismissal can either be ruled wrongful or alternatively automatically unfair. Both of these are for some quite technical reasons, perhaps a breach of contract, perhaps because they have whistleblown for something you're doing wrong in the organization and you've decided to get rid of them. But there are a number of different scenarios in which this can take place. Added to which, there are things like discrimination, and some of the highest ever awards have been made to employees who've been, in one case, with a car dealership for only a week, and who was awarded £180,000 because awards like discrimination are not capped. If you have an employee who's upset about being released, then if they're going to have a go at you, they will find a way. And one of the most common ways is to look at things like whistleblowing. I told you about that, and you did nothing, and then you got rid of me. Or discrimination, because the awards are much bigger, and it's much more worth the solicitors spending their time and effort trying to win the case. We'll go through all of this during the webinar. Hopefully you'll find plenty of little nuggets in there. The key point is you need to treat people seriously, fairly, and go through the proper process and procedures. Hope you enjoy the webinar. Good morning, everybody. Just to say, we are Backup HR. We do real-world business solutions to HR problems. My name is Guy Liddell. I will be joined shortly by Kathy Norton, who's our Director of Backup HR, and Peter, I can see Kathy has come online now, and Peter Stanway, who is our legal guru. We've got quite a few new attendees this morning. So good morning, Kathy.
Good morning. Sorry about the problems.
No problem. No problem. Just to explain to everybody, because we have quite a few new attendees this morning, the way this works is you are free to ask us any questions you like. We will answer those and get to those at the end of the presentation. They won't appear immediately in public, but if you put your questions into the chat box on the right-hand side, we'll check them and make sure they're relevant to today's topic, and then make sure they get answered at the end. We will send you a question and answers written out transcript of all of the answers after all this is finished. There will also be, that'll be later today, at the end of this broadcast, there will also be a short guide on how to deal with new starters in your organization, which is a fact sheet we produced a little while ago. So without further ado, let me just tell you what we're going to talk about today, because I think, to put this in context, if you talk to many employers, I think that they feel that when somebody's been with you for, say, 18 months, that they can sit down, have a coffee with them and say, sorry, my old fruit, I don't think it's really working out. If you just want to pack your bags on Friday and go, and we'll pay you what you're owed, then that is fine and there will be no comeback. And as we will be discussing today, there are considerable dangers in that approach. One of the things we're going to look at, we've looked at before, are employment tribunal statistics, because particularly in terms of things like whistleblowing, there are some interesting statistics coming out. We're going to define actually what it is that makes an employee a short service employee, talk about why that really matters, and then talk about, as we often do in these training courses, the banana skins. That you might think it's okay to continue like this, but it probably isn't. So, lots of headlines around, different to the last ones I've shown you, but there has been a surge in disability discrimination cases. Whistleblowing is a big topic that's being talked about by government at the moment, in fact, especially as whistleblowing claims have gone up. So employment tribunals are a real thing. And if you think just because people have been with you for less than 2 years, that you can avoid getting to tribunal, we can assure you that will not necessarily be the case. So here we are. In terms of employment tribunals, and Peter, I know you're on the, is it the employment tribunal panel?
Users group.
The users group, thank you. And you've kindly provided me with some of these statistics today. In reality, employment tribunals themselves are on the rise. The one interesting thing here is that between April and December last year, there were over 2,000 whistleblowing cases alone. And as we will talk about later, whistleblowing cases are particularly important because you get no protection from the 2-year rule if you're an employer in terms of whistleblowing cases. And that's double what it was about 5 years ago. So it's a significant increase. And you can see that the backlog, and that's what that graph on the right is, the backlog is now 47,000 cases in December. And looking at the projections going forward, that means anybody going to tribunal is going to have it hanging over them for at least a year before they get there. The increase is not surprising. Obviously, we've had the pandemic, and that has brought a whole load of things around, lots of redundancies going around, nervous workforce, people feeling they're being forced back into work. But the message from today is that short-term employees can be expensive, and that's because they can't go for the normal unfair dismissal claims. So lawyers get very creative in these situations and look at discrimination or whistleblowing or health and safety or personal injury, as we'll talk about later. There are lots of things they can look at that fall outside of the unfair dismissal laws. And as a couple of cases recently have highlighted to us as well, 13 weeks, which is the traditional time you've got to log a case. Once you've got past 13 weeks after somebody has left, it doesn't necessarily mean you're safe, because first of all, they've got to go to ACAS, and ACAS have said they've got a massive backlog, and so they're not processing things for quite a few weeks. Peter, I think they're 4 or 5 weeks behind, aren't they, at the moment?
I think nearer 3 or 4, but
okay.
Either way, you can't breathe a big sigh of relief 13 weeks later.
No, okay, because something could pop out of the woodwork.
And does.
And does.
And frequently does, because it's quite common that people get to 12 weeks and think, right, what am I going to do? I know, I'm going to put a tribunal claim in, see if they're going to throw some money at me. So it's quite likely it'll be over 13 weeks.
Yeah. Okay. So first of all, let's just define the group of people that we are talking about today, Kathy, the definition of what you would call a short service employee. And I suppose we ought to say that anybody who starts with you is by very definition a short service employee.
They are. We take a very simplistic view, which is anyone with less than 2 years service is in effect a short-term employee. It applies to anyone that's on your payroll. So they could be full or part-time, temporary, fixed term. And the key word here is continuous. You have continuously employed them. And obviously, furlough, as is a word we've only recently learnt, but now is an everyday topic, is part of your continuous employment, as indeed is any other type of leave that people need to take. And that can even include unpaid leave. For instance, if somebody wished to take 4 weeks of unpaid parental leave, that's still part of the continuous employment.
Okay.
And now the last point in terms of breaks in employment, at the moment, what the law says is things are continuous if people have been employed every week, unless there is a very specific, not less than 1 week break in service. Now, the government is actually looking to extend that to a month, but at the moment, it is still a break of 1 week.
Okay. And is that week constant? So in other words, if they've only been with you for a week and then leave and then come back a week later, is that exactly the same as somebody who's been with you for 18 months, leaves for a week and comes back?
Yes, is the simple answer. But we always say be really, really careful, because if you end up in tribunal over this, then tribunals will look very, very carefully at were you deliberately trying to get round the law by just terminating their employment for a week in order to stop statutory rights. And they're very quick to pick up on those kind of things. So we actually normally say, if you're going to have a deliberate break and you know you're going to re-employ them, make sure it's at least 2 weeks. That is a safer option.
Okay.
But even then, if you've done a deal with them which says you'll disappear for 2 weeks and then we'll take you back, that's likely to mean that you've still got continuity. It was just an understanding.
Yeah. Yes, you could imagine somebody saying, we'll pay you your Christmas bonus on the 15th of December, we'll see you back in January and you'll start a new employment all over again.
Yeah. The 1 week rule is almost misleading, to be honest.
Okay.
Yeah.
Okay. So look, the fundamentals, and we showed this slide and this principle when we did our keeping out of employment tribunals. The fundamentals of dealing with any employee, whether they're a new starter or whether they're somebody who's been with you for a long time, are that you should have and follow good process, have good documentation. You should treat everybody fairly and consistently, whether they're part-time, full-time, whether they're a new starter or whether they've been with you for a long time. And often people think that if they call them into that quiet chat in the coffee room and say, leave on Friday, is there anything that can change your mind? No, nothing. Without giving them the proper right of appeal, you put yourself in considerable danger. And the other thing we always say, point 3, is if you are unsure about anything, for goodness sake, pick up the phone before you act. When any employee starts, and we've all known employers who are not quite ready for their employees starting, but we know that the first few days, weeks and months set the tone for any employee, and that, you know, having been involved in recruitment for many years, that onboarding, getting some, we don't like the term, but it's what everybody says nowadays, getting somebody on board starts really from the time that the offer letter has gone out and has been accepted, to make sure that everything's ready for them when they arrive. Documentation nowadays, and we're going to talk about day one rights in a little while, what employees are entitled to from the first day of their employment. But contracts and handbooks are absolutely essential. And Peter, I think we talked a little bit earlier about induction, and it's something that, you know, we're always talking to our employers about, making sure that people are inducted properly.
I think, well, it's always been important. It's become even more important as people have been inducted remotely. And that, I'm sure there's been some superb examples and there's lots of good practice out there, but you just don't pick up on the vibes about people, or, you know, that says maybe they're a wrong 'un, or that actually they're not really sure what they're supposed to be doing and how, and don't like to ask. You know, they can't just bump into somebody at the coffee machine and say, how do I get a new pen? Or how do I go about filling a holiday form? Those sort of things that people pick up and make them feel part of the business. So you should make sure that somebody is properly responsible for their training, and rather than that person being a buddy, they ideally are given a buddy who they can talk to informally and just get to know and feel not like the newbie for too long.
Yeah.
Ought to be giving people and actually doing something about some sort of milestones for achievement, because all too often we hear people that say 3 months, the employer saying, well, they're rubbish. Well, how long have you known they're rubbish? Well, actually, from week 1. Well, why the hell haven't you said anything? Yeah. Well, all sorts of excuses follow from that. So people shouldn't get there. You really need to be setting expectations and giving people good quality feedback, because people need to know what they're expecting. They're not probably expected to do as much as their colleagues early on, and they need to know that. Equally, if someone's only doing half of what you'd normally expect people to do, you need to be saying, no, by this stage, we'd expect you to be doing X per day or Y per hour, whatever it is. So get those expectations right, and you're less likely to have problems, and if you do have a problem, they'll have seen it coming.
Yeah. Okay. Thank you. Thank you. So, Kathy, you actually put together this list, this slide for me, and you will better explain it than me. But the stages, because there are very different stages in the life of a short service employee.
There are indeed. These are what I would call the key milestones. Now, we regularly hear people say, I want to instantly dismiss. And we always go, there is no such thing as instant dismissal, except, and there's one very small caveat, which is if they are in the first month of employment and, note, and you have clearly written into the contract that in the first month of employment, no notice on either side, then there is such thing as an instant dismissal, but it must be in the contract. Now, probation, we'll talk about that later on, but the purpose of probation, which now the government has said is so important that it must actually be stated in your contract, what the terms of probation are. It is about, starting induction. Induction doesn't mean that you've got a finished product at the end of probation. It's just hopefully that they are on the road. The other advantage of probation is that you can, as long as you've put it clearly stated in your contract, you can give less notice. So if you normally, for example, put people on a month's contractual notice, during probation, you might wish to only put them on a week's notice. And again, it's advantageous if it doesn't work out. Once you've got past probation, then hopefully people are starting to gain skills, gaining knowledge, but they still need a lot of experience. But once you've confirmed that their probation has been successful, and of course you can always extend it a bit, then they have an increase in notice. You then have the 1 year anniversary, which in my experience, lots of people just completely forget about. At 1 year, an employee should be starting to show their worth and potential. They're still not there after a year, but they should be seeing their potential. But many employers just miss it altogether and so seem to wake up to the fact that there are problems when you're much closer to the 2 years. And that's, of course, when you get problems. And the other final thing is, it is 2 years. We use that as a short term, but it's actually 2 years less 1 week's statutory notice. So in fact, it's not 104 weeks, it's 103 weeks of a short service employee.
So it's 103. If you want to cut it right down to the wire, yes, then it's 103 weeks.
Yeah, not advisable. But, nope. But yes, so when you say 2 years, remember it's 2 years minus 1 week.
Yep. Okay. And this, I suppose, is why 2 years makes a difference, Peter.
Yeah.
Because there's lots of things that come after 2 years that are not around before that. So just perhaps explain what's...
Well, the big two are unfair dismissal, or the opposite side of it, which is constructive dismissal or constructively unfair dismissal, and redundancy payments kicking after 2 years. So that's why it's important. Redundancy's always been 2 years. The 2 year rule for unfair dismissal has been up and down from 6 months to 12 months to 2 years. Ooh, more times than a fiddler's elbow, to be honest. But so it may not be 2 years forever, but that's what it is at the moment. And it makes a difference in terms of notice periods, because even if you're on a week's notice, it's going to go to 2 weeks' notice after 2 years. And the big one for us is that with all our clients, we very clearly specify in their disciplinary procedures that the normal disciplinary procedure does not apply in the first 2 years. There'll be effectively a truncated, well, we've developed the term concerns procedure before 2 years, but after 2 years, you've got to follow your proper disciplinary procedure.
Yeah, and the important point, I suppose, to say here, we've already talked about it being 23 months and a bit 2 years, but the important thing to say here is that the law definitely makes a distinction between people who've served more than 2 years and people who've served less than 2 years. And so...
And the dates matter.
Yeah.
I don't want to be in tribunal arguing about whether someone has got 2 years and a day because of the statutory notice, and
of course,
arguments about when they actually were told, which these frequently issues that come up at tribunal.
They are, yeah. Okay. So rights from day one, there are a number here. Since April last year, many of you may well have missed it, unless you've been on our regular briefings, that actually a written contract is now required from, at the very latest, day one of somebody starting. There are all sorts of things that apply, like national minimum wage, needing a pay slip, and so on and so forth, holiday rights. There's an interesting one here, SSP. This is slightly tongue-in-cheek. It's a day 5 right. A common misconception is that if somebody phones in ill before they've even started work, that they're eligible for SSP after they've served the minimum of 4 days of sickness. But in fact, they must have at least done some work with you before they become eligible for SSP. That may not be the same for your own company sick pay, but it certainly is the case for SSP. And they're obviously entitled to equal pay, parental leave, and 1 month's notice of dismissal, certainly after a month. So those are the things that they absolutely have from day one that they start with you. Automatic unfair dismissal. It's a technical term. Peter, do you want to?
Yeah.
There are 3 that we've talked about, particularly in our coronavirus briefings recently, which are the first 3. Well, certainly the first 2. So give us a brief flavour of the first 2.
The first 2 are that it is automatically unfair to dismiss people because, well, officially it's because, but in reality it may be something like following raising a health and safety concern. Unless you've got very good evidence otherwise, if someone's raised a legitimate health and safety concern and then out of the blue that you're suddenly conjuring up another reason, that other reason is likely to be disbelieved. And that's for very good health and public policy reasons, which is people shouldn't be expected to put up with poor health and safety just because they've got short service. And people can raise that issue at any time, and in dismissing them will be automatically unfair. And it's increasingly an issue, and that's partly public awareness. But if someone says, I'm not staying in this workplace because my colleagues keep getting close to me, you've not done a proper risk assessment, or I'm not coming back to your workplace because I just know it's terrible, because you've not made it COVID secure, hate that term, but that's the term, then you're probably on a loser. Closely aligned to that is whistleblowing, because often those issues can be termed, well, they would be termed health and safety concerns. They could be termed whistleblowing, but whistleblowing can be also the traditional stuff that it was actually probably intended for, which is you are polluting the local river, you are fiddling your figures, you are bringing in illegal workers to work for less than minimum wage, etc., etc. But there's a close link there, and people can complain too. You can say, I raise health and safety concerns, and that's also whistleblowing, just to be on the safe side.
Yeah, I mean, at the moment they might be complaining to HMRC that their employer is using the furlough scheme illegally.
Oh yes, sorry. Well reminded, Guy. That I think is a big issue at the moment. I'm sure lots of people are looking at the government website and saying, why am my employer claiming furlough pay? Because we're all working hard here.
Okay, and we've dealt with in previous courses, so we won't go into flexible working requests, but every employee is able to make those after 6 months.
Yes.
There's a technical thing here, just that people don't asserting a statutory right. There are certain things that you can.
Well, there's so many statutory rights. Everything from time off for jury service through to being a school governor,
territorial army,
etc., etc. Yeah, pension trustee. I mean, most of them are pretty rare, but I'm probably the only person in the country who's ever done 2 tribunals over jury service.
Okay.
Yeah. You wouldn't have thought it's possible, but it is.
Gentlemen, we need to move on time-wise.
We do. Okay. So thank you, Peter. So those are automatically unfair dismissals. Kathy, again, contracts are needed on the first day of employment.
I think everybody is used to what needs to be going into contract. The 2 things I want to draw to your attention is that, as previously mentioned, April 2020, you now need to state within your contract not only what the probation terms are, but also what your training and what training you're going to give them, and specifically what mandatory training, in other words, the training that they must complete, they must successfully complete, and their employment is dependent on. So that is a very key difference that needs to be put in. Discipline and grievance procedures do not necessarily need to be included in the contract as long as they're cross-referenced in a handbook. And then finally, don't forget the right to work checks all changed as of December, but we've already covered that in a previous webinar.
Yeah, and there is a webinar available. If you want to see that, we can send you a copy to the recording. It's on our website. Okay, and the handbook, you've already said it needs to be cross-referenced or can be cross-referenced to the handbook or your policies and procedures.
Yes, I mean, the list there can be mixed. Some of it can be within the contract because everybody has different notice terms, and clearly a handbook is about standardized procedures. So some of this can be in contracts, some of it's going to be in your handbook, like for instance, discipline and grievance. It's not uncommon if people get benefits, which are the same benefits for everyone, that might turn up in a handbook. But also, as of April 2020, the Good Work Plan made it absolutely clear you must clearly state within the contract or cross-reference it elsewhere what the benefits are.
Yeah, and the important thing, I think, why we highlighted this here is that many of these things can be different for new starters than people who've been with the organisation for some
Which is the reason why it's often better to put that in the contract rather than in the handbook, which applies to everyone.
Yeah. Okay. And then finally, obviously, this is what you're expecting to be laid out for everybody.
Okay, there's a legal requirement to have discipline and grievance procedures. There is also a legal requirement, if you employ more than 5 people, to have a health and safety policy. Now, we don't recommend health and safety policy goes in the handbook, but we do mention it. So again, we cross-reference it to the fact that a health and safety policy exists. You would be highly advisable to have an equal opportunities policy for all of the discrimination reasons that we've previously talked about. I've already mentioned training. It's always wise to have attendance management policies. Our attendance management policies are probably one of the longest of all the policies that we have. But one or two of our clients that in the very early days said, we can't think of any circumstances whereby we'd ever lay people off, bitterly regretted making that statement last year when furlough came along. All of our other clients who already had layoff and short time working didn't have to go into panic mode because we said, don't worry, we already have this. Furlough is just a form of layoff. But I think an awful lot more organisations now recognise that they need these policies as well.
Yeah. And also, I think you made a note down the bottom here that even for short service employees, if changes are there, that you need to make sure that you document them in the documentation.
Yep, absolutely. And keep all of these documents up to date and review them on a least annual basis because the law changes every year.
Okay. And finally, and this is always a thorny one, we know, but new starters, are they outside your normal discipline and grievance procedures?
So the answer is they can be outside of your discipline procedure, but you need to make it very clear. It's what we call the 3-step approach, more of that later. But grievance, no, new starters are always within grievance. There is an implied contractual right to have a grievance heard regardless of service.
Okay, which makes sense.
It does indeed.
Peter, probation. The first point here, I think, is really important because I think a lot of people put your probation will be 6 months.
Yeah, and there's 2 ways of going about it, or you can do both. One is to say it's a probationary period of up to 6 months, because otherwise, effectively, it says you've got a fixed term contract for 6 months and then we'll review it. The other way, which is the way we predominantly address it, is just to be very clear about what notice periods are during that time, which effectively, by definition, says you may not get that far.
The common problem that many employers make is during probation, they forget about it. If it's 6 months, then they forget about it until 5 months, 3 weeks.
No, it's usually about 6 months and 1 week, sadly.
Yeah.
And there's probably a good reason why they didn't get round to it the week before, but really they should have got round to it a month before, or indeed 3 months before, or every month for the last 6 months, better still.
Indeed. And the other point is, although it's 6 months, if you're undecided, then you can say, we will give you an extension. And I think this particularly applied during coronavirus because a lot of people have been employed for 6 months, but nobody's ever met them.
Yeah, or they may not even have worked. They may have been on furlough most of the time.
Indeed.
I think I would also make the point that don't just extend it because it's a sort of soft option and you hope they're going to clear off themselves in that time. Only extend it if there is a realistic hope that they
genuine doubt. Yeah.
Or you just, you recognise that you've been so poor at your training and review that you think we ought to give them a chance.
Okay. And in terms of probation, there are really essentially then 3 outcomes. either you confirm the appointment full-time, or you say it's not going to work out and they leave, or you extend. So those are the three things. And if you do dismiss, there is no such thing as summary dismissal.
No. You still got to follow 3 steps. If you don't do it, people will come back with, really, it was because of that. If you adopt a proper procedure, if they say, it's because I'm female, for example, you can then say, tell me more about why you think it's because you're female. We'll investigate and deal with it and make a proper decision.
So the first thing, to be absolutely clear, is you can only follow this 3-step procedure if you've got it clearly stated within your disciplinary procedure that you reserve the right not to do the full disciplinary procedure for anyone that's got less than 2 years service. Our clients all have it in. So clients, fine. If you're not a client, listen carefully, learn and put it in, which is number 1. The person has the right to know in advance what it is that they're being accused of. So that letter is basically telling them we have concerns that are leading up to thinking about we could end up dismissing you. They have the right to be accompanied. So therefore, you must give them a minimum of 24 hours working notice to prepare and also to find their chosen companion. So that's step 1. Step 2 is actually the formal concerns meeting. Now, if there was documentation you were going to refer to at the meeting, you should have given that to them in advance as part of their preparation. You must go into the meeting with an open mind for the very reasons that Peter was just talking about, in case they raise an issue which could be deemed as discrimination, that they're being bullied, they're being discriminated against, and perhaps that's the reason why they're not performing. If those kind of things happen, then it gives you the opportunity to go, this is new to me, we'll investigate and we'll come back to you. You might still end up going back to the 3-step procedure, but it's important to investigate if people bring to the table stuff that you were not aware of. Make sure you have full notes of that meeting. It is impossible to talk and write at the same time, so get someone else sitting with you that can take notes. Always adjourn the meeting so that you're demonstrating that you have actually thought about what they have said at the meeting. The adjournment might only be an hour or so, but it is important to have that. And then clearly, if your decision is to dismiss, follow up that in writing. Your decision might not be to dismiss. It might be that you're actually going to extend their, and you might, for instance, give them a performance improvement plan as an alternative to dismissal. If, however, you do dismiss, step 3 is they still have a statutory right to an appeal. That appeal must be heard by a senior person not directly involved in the process so far, and who has got the authority, if necessary, to overturn the original dismissal decision.
You know, it sounds like a fairly full-on procedure, but it is important. And if you do it relatively regularly, then you get used to the mechanics of the process and making sure that it's done fairly.
And if you do it right, most people don't bother to appeal.
That's very true. Yeah, that's very true. And also make sure that your documentation to them is thorough and detailed. But actually, this 3-step procedure can be done and dusted in less than a week.
You've talked about the right to appeal, and it's essential, and how you have to handle it properly. And again, they can be accompanied, Kathy, yeah?
They can. They have the right of accompaniment. The importance of having an independent person is so that the appeal is fair and objective. And it might well be that a manager did rush through a dismissal without necessarily considering genuine grounds. And that's the whole point of an appeal, is that the appeal manager might think, actually, this is wrong. We need to give this person more time. So therefore, they can actually overturn that decision. Okay. Obviously, what they can't do, which is that final point, is they can't make it a harsher decision.
No, okay. Okay, which obviously in the case of dismissal,
you can't get much harsher than that.
You can't get much harsher than that. We've talked before about record keeping, but employment tribunals love to see things, and it saves you an awful lot of time at tribunal if you've got a lot of written evidence. And Kathy, I think everything, contracts, employment policies, and we talked about diary notes. Perhaps you can just talk about diary notes.
Okay, yes. I mean, these diary notes are basically the notes that you make. So, for instance, our colleague Jackie raised earlier this morning, what happens if you just had informal discussions with people about the fact that perhaps they're not delivering early on to your expectations? Then, yes, make diary notes that you actually had a conversation, and what was the main outcome of that conversation in terms of advice that you gave the employee in terms of things to do differently. It might be that you set out it in an email and say, further to our discussion, we have agreed the following, you're going to do this, I'm going to do that, etc. So even the informal stuff, it's very important that there is a note there somewhere that you can refer back to, particularly later on. Because let's face it, none of us, as we get older, our memory is not as good as before. But if it's in writing, then tribunals do tend to take it more as fact that it did happen rather than it didn't.
No, indeed. We've talked, and Kathy, particularly because you effective date of termination is the key thing here. And I suppose the key message that we want to get across to everybody today is don't wait until 23 months, for goodness sake, so that everything can be up for challenge. If you know somebody is not working out, you've got 2 years to work it out. You should know by 18 months if your processes are sensible. But just explain about the effective date of termination.
Okay, the effective date of termination is the date that the employee knows that they were actually dismissed. So if you picked the phone up to them after the meeting, because at the time you decided to let them go home, for example, so you end up phoning them, it's telling them on the phone that regretfully you've decided that you're going to let them go, and or you've told them in person. But what you can't do is rely on a letter, because the letter might take several days. And the reality is what happens is the employee says they never received the letter. Even sending a letter through by email, we were having this conversation earlier about putting read receipts on it. That's better than nothing, but it's still much better that you've actually told the person. One of the other points I'd like to make on this slide is I've lost count of the amount of times that clients ring me up and they go, oh, they've been with us, I think it's under 2 years. And I go, right, we're stopping this phone call now. You're going to go and get your personnel file and you're going to come back and tell me the date. And I can't tell you how many times they've gone, oh, it's 2 years and 1 week. And you go, right, okay, the advice I'm going to give you is a lot different to the advice I would have given you if you had dealt with this earlier. So that's why checking dates, any client that rings me knows that they always have the start date in front of them, because it's the first question I ask is when did they join?
We've had actually a question come in,
yes.
And rather than deal with it in the Q&A, because it's very pertinent to this.
Yes, that's right.
If a contractual notice period is 3 months, does that fall within the 2 years? So the decision to dismiss needs to be made by 21 months?
No. If you look at the last point on the slide, if people are getting close to the 2 years, less 1 week, particularly if they're on long contractual notice, you must, I repeat, must dismiss immediately. In other words, the day you make the decision to dismiss, you dismiss them as of that date. If you tell them in person or over the phone that is the effective date of termination, and you give pay in lieu. Now, the whole point of pay in lieu is that it's damages for breach of contract. You have effectively terminated their contract with no notice. That is what pay in lieu is, and it means their employment stops as of that date, as opposed to, so to answer the question, you've actually terminated them at 21 months and you've given them 3 months pay in lieu of notice.
But if
there's absolutely no ambiguity in the dismissal letter. I've seen letters or draft letters where it said, "Oh, we're giving you 3 months notice." I mean, 3 months notice. You mean 3 months pay in lieu of notice? Let's put in your effective date of termination is the 22nd of April 2021, and nothing continues beyond today. So they're not keeping the car for 3 months or the medical benefit, etc.
So the short answer to that is, even if they have 3 months notice, if you dismiss them, let us say at the start of the 23rd month, and say you leave at the end of next week and you get no notice, but you get pay in lieu of notice, your effective date of termination is next week, then you're 3 weeks inside the time and should be safe.
Correct.
2 weeks inside the time, I think.
Yeah, okay.
Pedantic.
Thank you.
And I would always argue that if you're dismissing people under these kind of circumstances, you wouldn't want them to work out their notice anyway, because they're, low in morale and they can be disruptive. So you would want to dismiss immediately anyway.
Okay, so here's the dangers, because we may well get to talk about these unless there's lots of questions, but not covered by the 2-year exemption are whistleblowing, discrimination, victimization, health and safety detriment. There are some others, but these are the sorts of things. So there are lots of statutory rights that people can be dismissed for, that they can take you to tribunal for, that are not unfair dismissals. And
they're actually worse than unfair dismissals because the compensation is unlimited.
Indeed. And these are the sorts of legal challenges that have come from the pandemic. And we've seen cases a number of cases of people with less than 2 years service playing these cards. Redundancy selection, and that's an interesting one, which I'm going to talk about with Kathy and Peter later, because although they're not entitled to redundancy, they may have to come into your redundancy calculations and your considerations. All sorts of things about discrimination, particularly as COVID has affected people in terms of age, in terms of disability, ethnic minorities, very differently. Working parents, especially mums who've got childcare, there's been some very, unfair consequences of pandemic, which people feel aggrieved about, quite rightly. Health and safety detriment, which most people never heard of before about 6 to 9 months ago, because of serious and imminent danger from COVID in the workplace, or a reasonable belief in it. And then whistleblowing, and finally, vaccination, and the ongoing debate about no jab, no job. And then lots of other things that have happened. Furlough, which this time last year we had not yet heard about, and pay a national minimum wage. We might have heard about furlough for about a week, to be fair, this time last year. So lots of things that have come out of the pandemic that have meant that you are likely to get more challenges than you did before. There are some banana skins here. We've already dealt with one of the questions. If you've got any other questions, folks, specifically about this, then please ask. But these banana skins, the typical one is people with 2 years service have no rights, but also they're only a temp, so we can do what we want. So,
there's two
temporary
risks.
Contract.
Well, there's 3 risks, actually, probably more. There's certainly the risk that you've got a temporary contract, which is fixed term, without break clauses. So you can't end it without paying compensation to the rest of the end of the contract. If you get rid of them because they're a temp, then they are protected by the Fixed Term Workers Regulations 2004 or whatever it is. Don't use that excuse. And finally, all the usual suspects of discrimination, whistleblowing, health and safety detriment still apply.
Yeah. agency workers, there have been some important cases recently on agency workers, so that you can think that they're not your problem either, because they're just short-term agency workers. And there's lots of case law in terms of, not case law, well, there's some case law, but there's also legislation coming in at the end of May to say for things like health and safety detriment, they definitely, you do have a duty of care for them, and you can't just ignore them. And the other one, which we covered in the Right to Work webinar recently, was that you get contacted by a government agency to say so-and-so is here illegally with no right to work. And obviously, clearly, we'd all think, well, they better leave immediately. Kathy, issues with that?
There is a big issue with that, which is you still need to, for instance, go through the 3-step process that we've talked about, because it could well be that they can demonstrate that they are in the process of putting in paperwork. They've put in paperwork, and because of the backlog, because of COVID, they're still waiting from the immigration department as to whether they've got the opportunity to stay in the country. So no, there is no such thing as instant dismissal just because it might appear that they're illegal. You still need to investigate. You still need to do the proper 3-step process.
We have some questions. We have some questions coming in. So let me just cover the last sort of banana skin slide, and I think I alluded it to earlier, particularly in terms of redundancy procedures don't apply. Kathy.
Well, the reality is that if you have a redundancy policy, which all of our clients do have, then it does apply to people regardless of service. And the reality is, although they may not be able to claim unfair dismissal through unfair selection, they may still be able to make a claim somewhere else, which was, oh, well, they picked me because I was the one that raised concerns about the COVID risk assessment that they put through. And they've made a point in making sure that they've made me redundant as a consequence of that. And it could well be, if you don't follow your proper redundancy selection criteria for your short service people, that they may be able to argue that there was a breach of contract as a consequence. So it is advisable to make sure that your short service people, particularly if you're making a lot of redundancies, it is advisable that you include them. If you've just got to let the odd person go, it is true to say we have given clients the advice, well, okay, if it's just that one person, then, and they happen to have less than 2 years service, then we'll do the 3-step procedure. But if you've got lots of people with short service and you pick only them for the reasons to be let go, that might well be questioned.
Okay, and there's just one important thing. We touched on it earlier on, and then I've got certainly 2 questions here. We already answered one of them, but after 6 months, and we think this is going to be increasingly common, and in fact the government's trying to make it, or there's certainly a debate as to whether it should be a day one right of flexible working requests. So refusing to consider a flexible working request, which they are allowed to make after 6 months, Cassie, I think I'm right in saying.
That's correct. I mean, at the end of the day, you can turn down a flexible working request, but you do need to have 8 operational reasons that you've put forward. We always recommend to find at least 3 or 4 of the 8 to justify your decision, and you do need to follow the process, which is obviously having a meeting, right to be accompanied, listen to what they have to say. If you turn it down, you need to give them written reasons, and then they have a right of appeal. Anyone that's a new starter, as we've defined, can still put in a personal injury claim. So they don't have constructive dismissal because they don't have the 2 years. But if they can demonstrate that the progressive bullying that they had caused them emotional and mental health harm, then they could put in a claim for work-related stress. It could be during the 2 years that they could argue that they've become ill and they've become sick as a result of the work they've been doing. For instance, they might have developed occupational asthma because they've been working in a very dusty environment, which they didn't previously have. Or it could be during their first 2 years, they have very serious or even quite serious accident or injury at work. They can whack in personal injury claims. So that's the other thing to consider, people with less than 2 years service in terms of legal recourse that they have.
And I think that one of the things that we were talking about this morning is that they've got, actually with personal injuries, they have 3 years to submit their claim after diagnosis. So in theory, if it can be proven, if somebody, asbestosis was what I used, or even minor lung disease, if you know somebody was a minor even for a relatively short period of time and they subsequently get 25 years later a disease, they've still got 3 years after that. So in theory, you could be on the hook 28 years later.
That's absolutely true. And that is the reason why occupational health professionals have to keep all of their medical records for 40 years, for that very reason.
Okay. So listen, that gives you a flavour of how to deal with new starters, and it's probably much more complicated than you think. But just remember, for every employee who you have in your organisation, good documentation and good procedures are absolutely crucial. Treating everybody fairly and consistently, and then whatever you do, if it leads to something like dismissal, then offering an appeal, however long they've been with you, is a really important part of the process. And finally, if you are uncertain about anything that you're doing, take professional advice. It will save you in the long term. Right. Let me very quickly go to a couple of questions that have come in. Peter, is the main difference in the three-step approach to a normal disciplinary procedure that there is no investigation meeting?
Well, that presumes that the need for an initial investigation meeting is a requirement. I would argue that the law doesn't specifically say that. I know it's become normal, but there will be circumstances where you say, right, come on in, Guy, I want to talk to you about coming in late in the morning. What have you got to say for yourself? That's your sort of investigation meeting, really, isn't it? Also, I think the bigger difference is that a normal disciplinary procedure has 3 stages. I use the word advisedly, not steps. Stages, i.e. written warning, final written warning, dismissal. It's that you avoid by having a 3-step concerns procedure.
And can I just also add, I mentioned earlier that you give people a letter, which is a formal concerns meeting letter. It should have identified within that letter what the concerns are. So arguably, you have already done your initial investigation. That's Indeed. What's in the letter.
Yeah, okay, good. This is an interesting one. How should we treat casual workers if they have a contract of engagement? Should they come off payroll in between periods of work, or should they be treated as long term? I suspect the answer from you, Kathy, is it depends on the circumstances. But
okay, if they are truly casual, it means that they do a piece of work, they stop. Therefore, you take them off the payroll. It's absolutely vital that you should do that, because otherwise they're not casual. They are what we would probably call variable workers, which is actually you do consistently employ them. A true casual worker, it's on, off, and that means on, off the payroll.
Yes, because otherwise we get into that term that you hate, but the press use a lot, which is 0 hours contract workers.
Yes, yeah, absolutely.
Who might be laid off for 2 weeks and then invited back into the office again to work like mad for another 2 weeks before being laid off at home. But that's, as I understand it, continuity of employment throughout that contract.
Yeah, so you need to give a clear instruction to your payroll department and just put up with their moaning.
Yeah, and they will. I understand it, but payroll evidence isn't absolutely determinate, but it isn't going to help you. If they
No.
stayed on the payroll for all that time, no P45, same payroll number, etc.
Fine. We've had one other comment, one other question come in, but it said thanks. So,
Thank you.
which is great. So there we go. That is our take on short service employees, people who have been with you for less than 2 years. You know, the summary is: be careful. It's probably a bit more complicated than you think.
Can I just say something, Guy, which is that obviously we have to focus on the potential problems, but the way people should treat people with less than 2 years service is by treating them well, training them well, investing in them, getting the best out of them, developing relationships, so that, you know, we don't get into concerns about when does the procedure kick in and how do we go about it. You know, the nature of our jobs means we have to sort of look at the worst case scenarios, but treating people well during that 2 years service is likely to be a good investment.
And can I add to that, because I totally agree with what Peter says, is if you're constantly having to use the 3-step procedure, you are failing. Somewhere along the line, you are failing. You're either recruiting the wrong type of person, or, as Peter said, you're not training them, you're not supporting them, and you're not helping them to succeed.
Indeed, indeed. Listen, as ever, thanks so much indeed for your time, both of you, this morning. Kathy, I'm glad you were able to dial in.
Me too.
Eventually. Thank you to all of the people who've attended. We've had a good audience this morning. And our next update will be in 2 weeks' time on coronavirus, which will be on the Thursday after the May bank holiday. So I wish you a very good bank holiday before then. And thank you for your time.
Bye-bye.
Goodbye.
Many thanks for listening today. I hope that you found the session useful. As ever, we finish with the caveat that this is only advice. If you need proper legal advice, then you need to take the appropriate measures and speak to somebody who is qualified to do so. We're very happy to talk to you. Give us a call at any time and we'll see if we can help. We'll tell you what we need to do. In the meantime, I hope you enjoyed this session and we look forward to seeing you again soon.